Welcome back to one more session. Today in this session I am going to explain about doctrine of severability. When a part of the statute is declared unconstitutional, then a question arises whether the whole of the statute is to be declared void or only that part which is unconstitutional should be declared as void. To resolve this problem, the Supreme Court has devised the doctrine of severability. A doctrine of severability, also known as a doctrine of separability. This doctrine means that if an offending provision can be separated from that which is constitutional, then only that part which is offending is to be declared as void and not the entire statute. So according with this doctrine, it is clearly mentioned that in any statute a particular provision which is unconstitutional and rest of the statute is constitutional, in that case only that offending provision can be declared as void and not the entire statute. Article 13 of the Constitution uses the words to the extent of such inconsistency be void. Under Article 13 it is clearly mentioned that to the extent of such inconsistency be void, which means that when some provision of the law is held to be unconstitutional, then only the repugnant provisions of the law in question shall be treated by the courts as void and not the whole statute. So whether a particular provision are to be declared as a void, it must interpreted by the courts. There is a case, that is A.K. Gopalan versus State of Madras, AIR 1950 SC 27. In this case, the Supreme Court, while declaring Section 14 of the Preventive Detention Act 1950 as ultra vires, the Supreme Court observed the impugned act minus this section can remain unaffected. The omission of this section will not change the nature or the structure of the subject of the legislation. Therefore, the decision that section 14 is ultra vires does not affect the validity of the rest of the act. So in this case it was clearly held that whatever the provision, whatever the part is unconstitutional, we have to declare that only should be as void, not the entire statute. This is about the doctrine of severability. So the conclusion is, according with the doctrine of severability, when by removing a particular provision, the nature and the structure of the legislation is unaffected, in that case the offending provision can be declared as unconstitutional. Thank you.